Hello, thank you everyone for being here. Thank you for all of the supporters that you see behind me. I'm Lisa Hepfner, I'm the Member of Parliament for Hamilton Mountain. I've introduced a private member's bill called the Keeping Children Safe Act. This is going to be transformative to our family court system. It is going to treat children like people, rather than like property that must be split equally in a divorce. Children are people. We need to listen to them. Around me here today, you'll see not only members of Parliament who are supportive of this private member's bill, but you'll see Women's Shelters Canada, YWCA Canada, the National Association of Women in the Law. We have 300 women's organizations across this country who have been calling for these reforms. And we also have some victims in this crowd. So I'm not going to take any more time. I'm going to pass the mic over to Suzanne Zakour from the National Association of Women in the Law to talk about why she raised this issue with me in the first place back in 2024 and why she's been working so hard to see these reforms happen.
Thank you, Lisa, and thank you to all of our allies that are right now standing behind us. And this is a collective work, and we're really grateful. So my name is Suzanne Zakour. I'm the Director of Legal Affairs for the National Association of Women in the Law, and we've been advocating alongside those 300 women's organizations to reform family law to better protect women and children who are victims of violence. Every other day, we have another survivor that reaches out, and they all share the same story. They left an abuser, they disclosed his violence, and then they got punished for being labeled, difficult, vindictive, an alienator. And years later, tens of thousands of dollars in legal fees later, they hear the message loud and clear. There is nothing you can do to keep your child safe. For survivors, the violence does not end with separation. It follows them into the courtroom. Women leave the domestic violence nightmare and enter the family law hell. So believe it or not, they come to us, they come to our partners, and they say, I wish I'd stayed. Because at least then I could try to protect my children. We have received over 250 testimonials, each more heartbreaking than the last. And I want to give space to some of their stories. My children and I denounced abuse, and I was accused of parental alienation. I lost custody and parental authority. All contact was cut off between my children and the entire maternal family. The children were removed by the police, handcuffed, and barefoot. Testimonial from La Rive-Sud. I was accused of parental alienation for not sending my child to court-ordered visits after she returned from her father's care with strangulation marks around her neck, Edmonton. I reported abuse of myself, and my son reported sexual abuse. My ex countered with claims of parental alienation throughout the proceedings. My son was ordered into reunification therapy and 50-50 parenting plan. Toronto. Another from Toronto. I'm falsely accused of parental alienation and facing reunification therapy. My son was suicidal after visiting his father. The family court has been ongoing for 8 years. I had to run for our lives with my little kids from a violent man just to be told that I cannot leave and have to give him the child every other week or I'm alienating them. I'm terrified as I know what he does when he's angry, and he's angry all the time. On a reçu énormément de témoignages du Québec également. À cause des accusations, un témoignage d'une enfant de Montréal, à cause des accusations d'aliénation parentale, la DPJ a recommandé la garde de ma sœur à notre père, notre agresseur. J'ai eu beau crier pour dénoncer la violence que nous vivions. Mon témoignage a été ignoré et pire, utilisé pour prouver l'aliénation que j'aurais supposément subie de la part de ma mère. Ce concept m'a privé de voix pendant 18 ans de souffrance. Un témoignage de la Naudière. Mon avocate m'a conseillé de ne pas dire aux enfants pourquoi nous étions cachés dans un centre d'hébergement pour femmes pour éviter que ce soit considéré comme de l'aliénation parentale. Two more. Testimonial from Southern Ontario. My baby was stolen from us 90 days ago because she disclosed abuse, and I protected her. I was called an alienator, and she was taken under court order, facilitated by the police, as she screamed for help and protection. This was the last time we saw her. Please help. And to end with a testimonial from right here in Ottawa. Being forced to send my daughter to her abuser while she was resisting has been one of the greatest forms of torture I've ever experienced. It is unbearable pain not to be free to protect your child. This is what despair sounds like when the law fails. And these are not isolated failures. They're patterned, they're predictable, and they're preventable. That's why we need reform. Because a system that forces a parent to send their child into danger is not neutral, it's complicit. Because protecting your child should never be a legal liability. And because Canada should keep its children safe. Today we invite every party, every member of parliament to support Bill C-223, a bill that exists because survivors have been saying loudly, clearly, and for years that the current system is broken. Nous sommes ici pour demander à tous les partis d'appuyer le projet de loi C-223 parce que protéger son enfant ne devrait jamais être un risque légal, parce que les victimes méritent d'être entendues et parce que le changement, c'est pour maintenant. Women are battling the law to keep their children safe, but our politicians can change that. So when members of parliament cast their votes, they won't just be voting on a bill. They'll be deciding whether a child's fear is taken seriously, whether a survivor is believed, whether the law reflects myths or reality. So we look forward to Parliament making the right choice, a choice that puts children's safety at the center of family law. Thank you.
And next, I'll invite Caitlin from Women's Shelters Canada.
Good afternoon. My name is Caitlin Geiger-Bartswich, and I am the Director of Communications and Advocacy at Women's Shelters Canada, a national organization that supports and represents 16 provincial and territorial shelter associations and over 600 shelters for women, children, and gender-diverse people fleeing violence. Bill C-223, the Keeping Children Safe Act, will have life-saving implications for children and families experiencing family violence and post-separation abuse. Throughout our work with women's shelters, and at times directly with survivors, we have heard countless stories of caring mothers being vilified if they or their lawyer mention domestic violence in family court. We've heard of women being told not to mention the abuse they have endured at the hands of their former partners, even if that violence was also directed against their children. Most of us have children in our lives in some way. Nieces, nephews, younger siblings, the children of close friends, or our own children or grandchildren. Imagine trying to protect them by explaining to a judge how dangerous it would be to leave them unsupervised with a violent person, only to have that argument used as rationale for why they should spend time with that person. This act will do exactly what its name suggests. It will keep children safe in situations of family violence by preventing courts from blaming women who are victims of domestic violence for not actively working to improve their children's relationship with their abuser. Domestic violence is the rule, not the exception, in cases involving parental alienation accusations. Protective mothers are too often punished for voicing concern about abuse. We've seen courts order children to live with an abusive father and prevent them from having any contact with their mother, even when the father's violence is well documented. This bill is essential to ensure that safety and well-being, not outdated myths, guide family court decisions. Thank you.
So when I won the PMB lottery at the start of the session, I knew I could do something more than just bring all these voices to Status of Women Committee and get their voices on the record. Suzanne Zakour had already drafted a private member's bill, and I spent this summer with a good friend of mine who has a family law practice going through the entire Divorce Act and amending it. And I'd like you to hear from her. She's a lawyer in family law, about why she found it important to invest so much time and effort in this. Susan, you're here somewhere?
Hi, everybody. My name is Susan Berry, and I've been a family law lawyer for 18 years. And I'm here to talk about the need to create a venue for children's voices to be heard in safety, okay? So what I see in my practice is children do express their concerns the first time they speak to professionals, the CAS, their OCL worker, but that information is immediately released to the parents, who then use that information to manipulate the children. The model that we have proposed in this bill is based on the German model, in which all children are interviewed in a custody situation by the judge hearing the case directly. And so what this bill attempts to create is a safe venue, whether it's by letter, by interview directly, for the child to communicate to the judge without the judge having to report back directly to the parents if that information would endanger the child. So 18 years ago when I started as a baby lawyer, very naive, out there to seek justice, I went to a presentation by Chief Justice Winkler of the Ontario Court, as he was then. And he said, the court system is adversarial. It was designed for property crimes and violent crimes between strangers. It was not designed for the family law disputes. No one has imagined a system designed to address family issues. And that speech has lived rent-free in my head for the past 18 years. I've heard social workers tell me that they would not recommend no contact simply because the court would not order it. In other words, social workers modify their recommendations to maintain their status as a trusted professional in family court. We have to remember that the rules of evidence, where an accused is entitled to know all of the information about them, is when their liberty is at risk. But it's not their liberty at risk in a family law case. It's the child's liberty. It's the child's well-being. And the child deserves to be heard in a manner that may not meet the rules of evidence as we know it for criminal cases, but they deserve to be heard in a way that lets them say their piece without fear. So this is not about winners and losers. This is about a better path forward so that the family law system we create will be a safe venue for children.
You can see the emotion in everybody's eyes as we talk about this. I had a 15-year-old victim lined up to speak to you today. She's had some trouble getting here. She's written 2 books on how to help other children avoid sex abuse by a parent. Next year, she's going to go to criminal court to testify against her father. She wanted to be here because she thinks that if this law had been in place, she wouldn't have had to go live with her abusive father. Absent Ismina, we have lots of other victims in this crowd, and I would like to bring a mother-daughter duo up, if you guys are okay to say a couple of words, just to share the experience that they went through in family court. Is that okay?
Yes.
Yes. Start with your names.
My name is Gianna.
My name is Gail.
Just tell us briefly what happened to you. Come up
I'm-
closer.
I'm a victim of attempted murder and violent sexual assaults. My abuser was criminally convicted, but in a criminal court plea bargain, I was allowed to move back to Canada, where I was born, with my children in exchange for my abuser receiving a non-custodial probationary sentence. So he has been on probation as a sex offender. At first, Canada protected me, but over the years, the alienation industry came into my story. And Canada ended up failing me. The Canadian child protection workers ended up participating in this alienation industry, and they've sent my little girl back to my rapist who tried to kill me. She has since turned suicidal. I've presented evidence of her distress to the family courts in New Jersey, to the child protection workers in Canada. A judge recently told me that the evidence I presented has no probative value. So my child's suicidal ideation and attempts and distress has no probative value. How is that okay? There's so much I could tell. However, I am gagged by the family court system, so I would go to jail if I exposed all of the actual crimes that were committed in my case. But one crime I can expose, that I can discuss, is that the alienation evaluator appointed by the court in my case committed felony forgery. He stole my electronic signature and the electronic signatures of my 2 eldest children to forge a consent form in order to cover for his violations of his standards of practice, whereby he was acting without consent. So when I reported that to the Canadian Ministry, I learned through the child protection disclosure files that the child protection worker had repeatedly begged the evaluator through emails for a consent form because of the fear of accountability, because I presented some evidence that they were not acting in the best interest of my children. That child protection worker literally lied to the police at one point to pretend to not know about the domestic violence in my case, even though she sat in my home office and she held in her hands the criminal domestic violence records, as well as a transcript from the family court judge who stated that this was one of the more extreme cases of domestic violence ever marched through his courtroom. She had lied to the police in the context of trying to send my son, who was then suicidal, to his abuser, despite police and doctors warning her that doing so, sending my son to his dad, would facilitate his suicide. Then she lied about the domestic violence to try to make that happen. I've asked police to hold her accountable. They said, unfortunately, they can't charge her with a crime because lying to the police is not a crime. And if it weren't for the alienation industry that exists, this would not have happened to my children. I would not have lost my little girl. This is the 7th year I have not seen her. And the family courts in New Jersey, as well as the child protection workers here, they don't even care to enforce the court's own orders for contacts while we're supposedly waiting for a trial. That has never happened. 7 years is not a temporary situation. She was taken supposedly for a temporary experiment pending trial. This is the 7th year. 7 years of a child's life is not temporary. I don't even know if I'd recognize my little girl if I saw her on the street. She was taken at age 10, and now she's 17. This is not okay. This bill would mean for me, it's too late to save my little girl, but it would mean some accountability, and that could help my older children who have been suffering tremendously, traumatized by the betrayals of the system that this bill aims to shut down by banning the use of the alienation concept in family courts. And I'm sorry I spoke a lot. There's so much more I can say, but I hope that it's clear to the Canadian government and to all Canadian citizens out there who have children or know people who have children. This could happen to you at any time. And this bill needs to pass so that this stops happening.
So what you heard is that there isn't a cottage industry of experts, so-called experts, running, reunification camps and, that are advising judges and then making money off of the decisions that judges make. So today, this evening, we'll have the second hour of second reading. Next week, we'll vote. I believe that we have enough votes to get this through to committee, but I'm here to answer any of your questions.
The Canadian Press. I feel like you answered all of my questions, and thank you all for sharing with us today. My question was going to be, do you have support from other parties to get this legislation passed?
Yes. Elizabeth May wants to second it. I don't know if she's done it or not. Leah Gazan has indicated that absolutely she'll support. Andréane LaRouche, like all of these people were at Status of Women Committee in 2024 when we had victims come for days to talk about this issue. So they heavily support. I don't have confirmation from the Conservatives yet. They've sort of been on the fence, so we'll have to wait and see whether we have their support. But with all the other parties, yes.
And my only other question, you kind of spoke about it earlier. Why was this so important for you personally to bring forward? Why choose this as your private member's bill?
I was horrified. I was parliamentary secretary to the Minister for Women and Gender Equality in 2024. Suzanne Zakour approached me with all these victims. I used to be a journalist, and I use everything I ever learned as a journalist. And the difference right now is that I have more power to act. So when I hear those stories, I don't have to just share them. I can actually do something about them. It was the first thing I thought of. When I won the PNB lottery, I called Suzanne, and I'm like, okay, let's go. Je peux aussi en français si vous voulez. C'est bon? Okay. I encourage you all to speak to some of the other victims in the crowd. They'd be happy to speak to you one-on-one about this issue and their personal experiences with the family court system. Thank you for being here. Thank you for your attention. I really appreciate it. Tell your MPs to vote for this bill.